Good evening, everybody. Welcome to, are we online? Are we live? We are live. Welcome to the Warrant Committee meeting, September 29th, 2025. The clerk is informing we have a quorum. Karen, would you mind calling roll?
We have Jay Fundley, Macy Lee, Elaine Craighead, Grace Doherty, Larry Johnson, Brian McGuire, Lee Michael McLean, Ronald Sia, Nicholas Tangley, and Cecile Yang. You have a quorum.
Okay, great. I think much of tonight will be discussing the lighting bylaw, and we do have the chair of the select board in here to help us. He does have a hard stop at 7:45, so let's make good use of him while he's here. A couple of business things to take care of first. I sent all of you in one of my flurry of emails, when I sent like 4 or 5 emails at a time, I did mention that the Massachusetts Association of Finance Committees is going to have an annual meeting on the 18th of October. I went to it 3 years ago, and I haven't gone to it since, but I intend to go this year. It was good. They had sessions talking about what types of things should you think about. Like this time there's a Town Finance 101. There's also a what do you need to know about employee healthcare costs and like that. I spoke to Mr. Milano. He said, and we have a budget to pay for it. So it's in Sharon, an easy drive away. Mr. Milano said we could send me plus 2 or 3 members, no problem. It would be paid for. So I haven't heard anyone say they want to go. I think it's a good thing to go to if you're able to spare the Saturday on the 18th of October. So let's talk about that. One other piece of business I want to take care of. There was a motion last week that I think I misunderstood. I think everything worked out just fine. I just want to clarify so there's no precedent being set. There was a motion that I interpreted to mean if this motion passes, the warrant committee can't make certain amendments. Whether that's what the motion was intended to be or not, that's what I thought it meant. I think we had a good discussion. I think the votes we took reflected the will of the warrant committee. I'm not at all concerned about that. I just didn't want to set a precedent for going forward. We'll have meetings and people will make motions that we can't make a certain amendment or can't make another amendment. Cutting to the chase, that's not a legal motion. So I'm just putting that out there so it doesn't set precedent. And I think we'll go straight into the lighting bylaw. Before I turn it over to our experts, I do want to say a couple things about the lighting bylaw, just to frame the discussion. Now, and maybe I'm projecting, I am projecting. Some people might be frustrated. Why is it, in this room, in this town, why is it taking us 8 months to get here? What should others, I think someone else should have been doing something else in the last 8 months, or this committee should have done that, or whatever. Those frustrations are out there. I share some of those frustrations. But let's keep in mind, our discussion is to discuss what do we recommend at town meeting regarding this article. After the warrant committee, I'll get together with you and a beer and we can discuss our frustrations at length. But let's try to keep it productive here. And on the same note, for any article we have, including this one, we've got the article in front of us to make a recommendation on. We might wish it was otherwise. And to not beat around the bush, some people might say, I wish this was a zoning bylaw instead of a general bylaw. For example, that's a valid feeling, but it doesn't affect what we're doing here tonight. We have the article that's in front of us. We'll make a recommendation on that article.
It is more difficult to pass a zoning bylaw at town meeting, though. Just FYI.
Yeah,
that might be why it's not a zoning bylaw, because it requires a 2/3 vote.
I was listening to a meeting we had about 6 months ago, about 4 months ago. Math is hard, and we spent a long time discussing why it was or was not a zoning bylaw. And I just want to keep the discussion focused. So with that being said, I would like to invite our select board chair Ben Zoll to join us at the table, and I believe. So our 2 experts on this are Nick and Ron, and Nick has put together a PowerPoint, which I will be sharing. And all right, let me, I'm not even on, I'm sorry, I'm not even on Zoom yet. Unless somebody else is, well, I don't know if there's gonna be a faster way to do this.
Well, while you figure that out, can we talk about what our process is gonna be here? Should we have Mr. Zoll kind of walk through what the select board's position is and sort of respect and honor the time that he has available? Or do we want to kind of walk through where we've come out as a group of people?
Opened up the
Stop. Okay. I absolutely want to respect Mr. Zoll's time. Also want to respect that maybe he didn't come here with the presentation ready.
No, that's fine too, right? So
Yeah.
we could walk through some of the issues and
Yeah.
that we found and see what the conversation is like, if that makes sense, right?
Yeah, and I think Jay shared the markup of the article with folks.
I apologize. I shared a marked up version of the article, which has gone through town council review. I shared it less than 10 minutes ago, and I apologize.
Right. So
Reading.
backing up the bus a little bit, right? So we've had one or two conversations of different lengths in this group over the last couple of meetings. Based on the conversations that we had, Ron and I marked up the article that had been proposed by the select board that got shared back to the select board. They had a chance to talk about it at their meeting last Wednesday, and they were generally in favor of all the stuff that we had proposed, which is great. They shared that with town council over the weekend and came back to us with a couple of thoughts. So I think that's what we're kind of working on, right? So that's the kind of article that's before us. So the warrant committee basically has made changes that haven't been officially approved by the select board by a vote or anything like that, but have been unofficially approved and endorsed. And so that's what we're working towards, I think, today. Going through it and hearing the conversation that we'd had as a group and some of the conversations that have had at prior town meetings, we've kind of identified a half a dozen different issues that maybe we want to talk about as a warrant committee, and make sure there's sort of broad consensus around that. And that's what we think is reflected in the article that, kind of we're thinking about recommending. So process-wise, I think that's what we're talking about trying to do in this discussion here today.
That's all right.
That sounds right to me. And yeah, just the obvious caveat, I'm speaking for the select board, but I'm not the select board. So
Right.
what I'm saying is I'm trying to, pass along all of our feedback. And I will say that the select board won't be able to meet again before this goes to print. So we will at some point have a vote on what the warrant committee recommends, but that will be after the warrant's gone to print. And if for some reason we need to have a green sheet or something like that, we can come back and discuss it. But that's where we are for now. So the feedback that I offer you now is the feedback from the select board. If you change the article around, the select board will still have an opportunity to weigh in on it and comment on it at the meeting.
Yeah, that's good.
Sound good?
Yeah.
Okay.
So I don't know if I'm stalling for time.
Would you like me to start sharing? No, I'm good. I'm good. Thank you.
So the way we'd sort of talk about this is I'll maybe kind of kick off the conversation. Ron's going to chime in on all the things that I left out. And then, we can have a conversation around the table about other things if that's okay with everybody. We did do some research on town comparisons. If you want to go to the next slide, Jay. According to Dark Sky, Massachusetts, there are 64 municipalities that have adopted some form of outdoor lighting resolution. That's as of May of 2025. So that's a lot of communities. The list is on the next page. And we kind of looked at the details on 5 of them that we think are a little bit more comparable. I would say, when we see the list that comes up in a minute, a lot of those communities I think are more like Western Massachusetts communities or Cape Cod communities, and maybe not representative of what I think of as Milton comparison. But for way of comparison, that's according to this organization, which I thought was helpful that it's a place to start. As we sort of look at what we think are some of the issues that we're going to try to talk about, and we have a few slides on some of these different topics. There's certainly enforcement challenges, of the way this is applied. I think that's just a reality of what's going to happen here from the point of view of the town of Milton. I think the key issues are an appeals process, what the brightness levels are, what the issues around dark sky versus light pollution versus light trespass are. And I think with regard to a couple of provisions that were originally in the article the select board had proposed, there is a motion sensor exception in the bylaw, which I think makes sense, but I understand some people want to talk about. And then there's, maybe questions around the fine amount. So I think those are the issues we're going to try to talk about here, if that's all good with everybody. If you want to go to the next slide, please. So these are the 64 municipalities, according to this organization, Dark Sky, Massachusetts, that have some sort of light ordinance. I looked at some of them. I highlighted 5 on the page that I've tried to read their bylaws in more detail on for comparison purposes of the ones on the list. Those are the towns that kind of stood out to me that had some more information. I would say, as we look at this, that, having started trying to do some research on town by town, I did actually find some stuff in 2 other towns, Hingham and Canton, and we have some reference to some of that research. I am by no means an expert when it comes to bylaws. I am drinking at the fire hose here, fast and furious, as a new member of the Warrant Committee and all these issues. I found bylaws really challenging to read, but I did my best to go through these 5 as thoughtfully as I possibly could and try to draw out some observations. If you go to the next page, the first observation is around the appeals process. This is one of the areas that I think has come up in a couple of different iterations, because this has come before town meeting. This will be the 3rd time in one form or another. In the first 2 iterations, in the original iteration proposed by the select board, there was no appeals process in there. What I think is interesting about this is the proposal for Milton is that this falls under a general bylaw. Every other town that I've seen so far, it's under a zoning bylaw. So that would make the appeals process a little bit more straightforward. If it was a zoning bylaw, I think the appeal would go to the zoning board of appeals. And we sort of had to come up with an appeals process. The proposal that we had made was that the select board would appoint a committee of 3 people to hear appeals. And based on that draft that went back and forth with town council and the informal conversation with that the select board had last Wednesday, that's the proposal that's moving forward at this point in time. So that's kind of the appeals process. I think having an appeals process is a really valuable feature of the article. And I guess I'll just stop there, see if people want to add, or we could talk about the appeals process.
Yeah, well, maybe one point Nick mentioned earlier, and maybe the prior slide about enforcement. That's not really our purview to think about the strain on the town resources, but I'd leave that to the executive side. You and select board and the administrator would have to think about resources, and if it is 4 hours to send a town employee to go check somebody's house, I assume there's going to be some resource drain. So that's something I think Nick mentioned. There's a 4-hour kind of window for any violation to be inspected. You just send an employee out. It's going to take up 4 hours. Do they take a half day, or are there budget concerns? We leave that to you.
I assume it would be at night.
Yeah, I was gonna say, it would have to be
I
from.
think that's why it's an extra call out, is what I was
Yeah,
told.
for sure.
Not at night and non-regular work hours,
Yeah.
4-hour unit minimum. That's what I was told. So again, I don't think that's something for us to discuss. I just think it's an observation of a challenge of the application of the bylaw.
Yeah.
But I think it's important to note.
Yeah, and then on the appeal, I know we've talked it before. I think this is something that came up at town meeting, that there should be some kind of chance for the property owner to discuss with the other neighbor in front of some impartial body. I think the earlier version really left it to the inspection personnel to make that determination. But I don't know if we want that person making judgment calls on arguments with neighbors. So that's why we had kind of pushed for an appeal, so that there's some process that people can advocate for.
Yeah. I think in our mind, hopefully, in an ideal town, which I think Milton is very ideal in many ways, if someone has an issue with their neighbor's lights, they could talk to their neighbor, and the neighbor could adjust the lights or explain why they need to be on in a way that satisfied the neighbor who was complaining, and nobody else would be the wiser. And I bet that has happened in town over time. If somebody puts a new light on their garage and it's shining right into somebody's living room, that's the way that this goes. This is really for the intractable solutions where the neighbors are failing to come up with a compromise. But I agree with the idea that both sides should be represented in the argument process. And so, and I think the select board felt having an appeals process made a lot of sense.
Yeah.
And I don't know if we want to skip ahead. So, Mr. Zoll, were you copied on the emails between us and Mr. Milano and the town council?
Just today?
Okay.
Yes. Yeah.
Yeah. So again, being conscious of your time, I'm going to maybe skip ahead to the solution that is in the draft right now, is that I believe it's worded that the select board will appoint a 3-member committee to review the appeals, not necessarily members of the select board, but just the select board will pick 3 people.
I think almost certainly not members of the select board. I think that sort of reflect. We felt like the select board itself is probably not the right body to be hearing this, and so And we would be open to suggestions. If you thought somebody from ZBA should be on the committee, we could see if that's a possibility. I think leaving it unspecified kind of gives us an opportunity to figure out who the right folks are. And then in the future, if we want to go back and amend and codify what the specific members of that committee are, we could do that.
Yeah. I just wanted to get your thoughts on this specifically because
Of course.
this was the topic that the select board, it might have been the only topic the select board discussed.
We'd like your other changes.
Yeah.
They're great.
Great. I'm just saying we want your feedback on this.
Yes. Yeah, no, appreciate that.
And I know the select board threw out a couple of ideas, and this is the one that.
So I can't speak, substantively on behalf of the select board, but I would anticipate that they would be fine with a solution like this one, with us appointing 3 people.
Okay. Next slide.
Anybody else want to talk about the appeals question or process?
I mean, is there any reason it couldn't just be the zoning board of appeals just to kind of simplify things? I mean, I don't need to.
I mean, yeah, I think I'll address that. I talked to Mr. Milano about that. And one reason, the zoning board of appeals by law, I guess by law, if there's a zoning violation, it goes to the zoning board of appeals. This, as we've said, is not a zoning bylaw. So when I talked to Mr. Milano, he sort of said, the zoning board of appeals, they're busy. And this would be asking them to voluntarily pick up something that's not their job.
Okay, yeah.
So if they raise, between now and town meeting, if they raise their hand and say, we're happy to pick it up, they'll do a green sheet and say them. That's
Yeah.
Okay.
I think the select board would agree with that too. We're happy if they wanted to take this on.
I have a question.
There's the reason.
With regards to the committee that's going to hear the appeals, these 3 individuals, what sort of background would you be looking for?
So I think we'd probably want, a couple of different skill sets represented. One would be optimally somebody with some sort of experience in the building or lighting space, whether that's as an architect or as somebody who as an electrician or has that kind of a background. I think we would also want to make sure that we had a fairly diverse set of folks that were represented there, so that, if one of the rules is around cultural, like holiday lights and things like that. So you'd want to make sure that somebody understood when a menorah needs to be on or something like that. I think that would be helpful to have some diversity there. Also, I think some geographic diversity would be nice, because I think, what might be super bright around Turner's Pond might feel less bright to somebody who is used to living in East Milton. And so they may be able to, provide some commentary there.
I have a follow-up question to that.
Of course.
So I'm looking at the most recent version very quickly, and I don't see on there the terms that these individuals that would be sitting on this committee. Is it a lifetime term? Because it's not stated in this article. So I'm just curious.
So that we didn't write this particular language, so I think we would be open to that. My guess is that probably the select board would have like most of our committees, we would have like a 1-year appointment that, people would be up, and if they wanted to stay on the lighting committee, they could probably do that, unless they were shining flashlights at everybody. I don't know.
Are you gonna, is the intention to include that in this article before it goes to vote? Because otherwise, it should be clearly stated.
I might, maybe I'm splitting hairs here, but I am splitting hairs. I would say this article doesn't establish a committee. The select board is expected to establish a committee. And the select board establishes committees, right?
Yes.
And you establish them, you say, here's what we want, here's the terms. So.
But I'd like to hear from
Okay,
Mr. Zoll. What
Yeah,
about-
no, I think that Mr. Fundling's right. So if the town meeting approves this, and Mr. Milano's not online, is he? Because he could probably jump in with the process. But my understanding is that the town meeting if the town meeting tasks the select board to create a committee to deal with this, then the select board at a future meeting, ideally like the next one or one there shortly thereafter, would then have a discussion about what does this committee consist of. If people had ideas or input and they wanted to, to give that to the select board, they would have an opportunity to do that. And then we would basically come up with a set of bylaws or, regulations for this committee, vote on them, and then seek either volunteer appointments or seek out people that we think might be qualified and ask them if they'd like to serve. So I would imagine if this passes in October, you'd probably have something in place committee-wise before the end of the calendar year.
Thank you.
Welcome.
Just so that those bylaws would be determined by the select board, they wouldn't need to go back to town meeting, right?
I mean, basically, the committee would it would be pretty simple. Like, here's your term, here's the title of the committee, and this is your task. And so, if their task is to mediate or sort of rule on judgments that have been made about lighting, then I think that would be the straightforward task.
Well, really what it would be is a recommendation to the select board, because the bylaw gives the select board the authority. You can't delegate that authority. You would just
That's
be
right.
asking for citizens to give you feedback.
That's right. So the committee would come back to the select board and say, we recommend that this ruling be upheld, or we recommend that this ruling be overturned, and we would probably vote according to the committee.
Yeah, I'm just hoping it doesn't have to go back to town meeting, because that would take another year to figure out. But yes,
Yeah.
understood. I was looking at the language in the actual article. One thing I didn't see, so there are 3 individuals. I would assume it's majority rule. It doesn't say that, but I think that could be helpful. So we know, okay, it's not just one person can say, vote a certain way, and then the appeal goes that way. It has to be a majority of those 3.
I don't know if that we would have to specify that, but that would be my interpretation, is that unless it was otherwise specified, it wouldn't require a unanimous.
Again, they're not really making they're not voting on anything. They're
I would
just
think that
making
could
a
go into the
recommendation.
bylaws that the select board.
So they could
decides.
report back and say, hey, 2 of us felt this way, 1 of us felt that way, and give us, it could be a little Supreme Court situation if it really gets serious. But my God, I hope it doesn't come
I
down
actually have
to
another question.
that. Yes.
For notice purposes, so it does say in here that the committee will make a decision. Is that decision going to be in writing so that it provides adequate notice to the alleged violator? Or is it just going to be a decision rendered at the hearing? I'm just asking because if there's further appellate rights that stem from if there's a denial, or if there, I'm just wondering where it
I
goes.
would imagine that we'd ask the committee to make a written recommendation so that they don't have to come to the select board and give us the blow by blow, unless they needed to.
I suggest that language
But I
be in
think
there
that's-
because it says decision throughout that part.
Yeah.
Perhaps the word
We
written
could
should
have
be in
written
there.
decision.
Yeah.
I think that would be fine.
It's just the
I
recommendation.
think that's a good addition.
To clarify something you said, Mr. Zoll, and you said, Mr. McLean. Oh, wait, what? Why am I drawing a blank there? Now, it's my understanding from reading this that the committee makes the decision. Both of you said things that sort of implied that the committee recommends a decision to the select board, and that's not how I read it.
I haven't read the new language.
Totally
but
fine.
yeah.
Totally fine.
Yeah, it says appeals shall be heard and decided by a committee of 3.
Pretty conclusive.
Yeah.
It could be that the language is not accurate.
Oh, I think it's.
I think if the bylaw specifies that the committee can make the decision, they probably can.
That's true.
But in the previous version, it was the select board.
Correct.
So yeah.
In the previous version, it didn't say anything about an appeals process. Maybe the one we marked up way back when.
The markup had the appeal in it, but then
Okay.
this is now with the town
Okay.
council input. So this is, I think that's right, so that they would make the decision. And honestly, I think that's probably more straightforward anyways. But I still agree with the idea of having it as a written decision.
Any other conversation about appeals?
Yeah, I would just say if this committee does make the decision, I would think we can make the recommendation that we specify the decision is written. I would also specify that it's a majority decision, so they don't get hung up, because I don't know that that's clear.
Are you saying as opposed to unanimous?
Yeah.
Okay.
Or that one person could stop the
Yeah.
enforcement.
I don't have them at my fingertips, but the town bylaws have some sort of generic
Okay.
terms about
Yeah.
committees. For example, Brian, when you said Brian and Grace, both of you, when you looked at the MPIC, you said, does it need words around what a quorum is? And the answer was, no, we have general town bylaws that address things like that. So I don't have them at my fingertips, but I'm guessing it's things like majority rules.
I would, and if the warrant committee agrees that majority decision is right, which I would think would be the right call, I would just check with Nick and make sure that was, if it's covered under the general bylaws, then I think you're all.
Yes, with Mr. Milano.
Yeah, sorry.
We have a Nick here.
Yes.
We've got to.
And then, so we'll follow up with Mr. Milano.
Yeah.
The only other question I had was, so it says appeal shall be heard and decided within 60 days. If no decision is made within 60 days, the appeal is deemed denied. So I'm just worried if the select board can't get 3 individuals, let's say they have 2, and it takes a month or 2 months to fill that 3rd spot, can the 2 individuals hear an appeal without a 3rd? Because I ordered a timeline, and this vacancies make me concerned that the clock will tick.
So I think, and this is again where Mr. Milano has the real official brain, but I think using my experience as select board, that none of the bylaws that we pass at town meeting are law until the Attorney General signs off on them. So there's kind of a dead time between when the laws or when town meeting closes and then when everything officially hits the books. So if the AG's office has to look at this, it's usually like a 3 or 4 month timeline. So again, with the goal of having a committee in place by December, I don't think the law itself or the bylaw itself would be effective probably definitely until the AG has signed off on the bylaw, which is probably January, February-ish. So I don't think that we would run into that. I think if we did run into a situation as we have now on the select board where we have an even number of members, if there's a tie vote, there's a tie vote. And the tie usually means no action is taken. So I would think if there were 2 people on an appeals committee, again, this is probably a better question for town council, but if there's 2 people and they are tied on whether or not to overturn it, then it would be upheld.
Right.
Anybody else on the appeals? Any more questions? Any more discussion? We'll go to the next item then, which is the brightness levels. So you guys might remember from the conversation we had, it was like a month or 2 ago with Sean O'Rourke, who was, I think, one of the people that's really kind of helped determine what the level is for Milton. The Milton level is 10 lux. I did reach out to Sean again to sort of figure out, more precisely where he came for that. He was going to get back to me. It has not yet, so I apologize about that. But trying to put this in context, if you look at other either written literature about brightness levels or other of bylaws for other towns, there seem to be 3 terms mentioned. There's candela, which measures brightness, visible intensity; lux, which tells how bright the surfaces are; lumens, which tells how much light is given off by the bulb. So clearly, to people that are really in the know, these 3 things actually mean something different to each other. To me, they're all kind of the same. And the Milton bylaw is written at 10 lux. And so I tried to figure out a conceptual definition of what 10 lux is in words that I could relate to and understand, right? And so I found 2 different definitions out there. So the first one is something I think we'd read at one of our meetings before when we were doing Google searches here in this room. 10 lux is considered a very dim level of light compared to the illumination from a candle flame at a distance of 1 meter. Seems pretty light to me. It's slightly brighter than moonlight, providing a soft ambient light. In practical terms, 10 lux is often used for creating a cozy atmosphere rather than for tasks requiring bright lighting. That's one definition or description of what 10 lux means. And if you look down at the next section, there's a difference between 2, 5, and 10. So starting with the 10 one, 10 lux is ideal for public parks and gardens, ensuring safety and security with adequate visibility. These levels help to maintain a safe and functional outdoor environment, reducing the risk of accidents and enhancing overall safety. Clearly brighter than 2 and 5 lux, but seems to be kind of aligned with what we're trying to do in this bylaw.
You I think just uncovered something that I uncovered, which is the definitions for lux vary dramatically from what I found, and what you just read for 10 lux is not in agreement with the first bullet. 10 lux is considered a very dim level of light comparable to the illumination from a candle flame, blah, 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 right?
Yep.
And then if you read down the bottom, 10 lux is ideal for public parks and gardens, ensuring safety and security with adequate visibility. That is, so how do you...
I don't know, I might argue they're one and the same, right?
What?
Sort of, you could say that, you know, a level of lighting that's appropriate for dim lighting is appropriate for safety in a public space. So I agree they're not exactly aligned, but you could argue that one is the same as the other.
One thing is, I think distance plays in, right? Where's the measurement being taken? So one candle at a meter, let's say this is like my arm, I think that's what 10 lux is in that first definition. In the second one, it's a public park. It doesn't talk about distance. I think that's a very general statement because a park could be 1,000, feet in one direction. So I think that's why these won't make sense together because the second definition is just a broad discussion of applicability of 10 lux, not where do you measure at.
It might help or it might not help if we went to the next slide where I did some math. So yeah, it's got pi in it. It's
a great bylaw, a rational number.
We'll cut to the chase. I just grabbed this math, formula off the internet, a formula out of a physics textbook, doesn't equal real world, but I wanted something like, so stepping back, I don't think anybody wants to pass a bylaw and then we realize, oops, 50% of the people in town are in violation of this bylaw on day one. So I was wondering, if I have a light bulb in front of my house, am I going to be in violation of this bylaw? So I said, let's take 2 light bulbs in front of the house. For old people like me, we'll call them 100-watt bulbs, even though they're not 100 watts anymore, but 100-watt equivalent bulb. So you have 2 of those in front of your house, and let's say your sidewalk is 20 feet away. Now, your sidewalk is not your neighbor's property, but let's start with that. Your sidewalk is 20 feet away. 2, again, quote-unquote 100-watt bulbs next to your door, 20 feet away. We can skip to the end. That's 6.8 lux.
At 20 feet.
At 20 feet.
Okay.
So if my
That's where all these things are measured from, is from the property line. That's what the Milton bylaw calls for, and that's what the other bylaws that I observed are. It's where you measure it at the property line, not at the source of the light.
But the light could be on the property line, right? The light could be on the property line.
Right, but it's about how, yes, it could be, but the bylaw that Milton has written here and that the other towns that I observed, the measurement of the brightness of the light is at the property line. So if your light is at the property line, then presumably it has to be dimmer because it's the shadow or the light that goes on beyond the property line.
Right.
So yes, you're right. Yep.
So
I don't know where the light is located.
Yeah.
Depends on how high in the air it is, so how far it projects. There's a lot of different factors that go into it.
And I also hope this helps with the imagination question of, we can sort of imagine there's a house with 2 light bulbs. Here's me at the sidewalk. How bright is that? Hope that helps with the last slide, was getting us to imagine.
So
Sorry to interrupt, but remember when Sean O'Rourke came in.
Is that Andrew?
that was Andrew.
Okay.
Yes, it is. When Sean O'Rourke came in, lumens is the amount of brightness on the bulb itself. Lux is the illuminance or the sort of level of light visibility at the point of measurement. So the same lumen bulb for a light that's at the property line would result in a lumen or a lux that is higher than the equal light bulb in terms of wattage measured from a light source that's 10 meters away from the property line. So lux is, in terms of the visible amount of light, is going to be the same. It might be different for different bulbs at different distances, if you will.
Yep.
Macy, were you going to say something?
I was, and I can't remember now.
Okay.
It totally escaped me. Thank you.
So we did look at some of the other towns on the next slide to see what kind of standards they have based on their numbers. So Milton's at the top, proposed 10 lux at the property line. It's interesting that Andover and Belmont don't give a number. They have how far it is from the street level. There's a diagram at the end of this deck if we want to see that. But basically they're saying it should not protrude beyond the property line. Wellesley has...
So that's 0.
Huh?
That's 0.
At the property line. Yeah, based on the lightness. You might be able to see the light, but...
They essentially set 0 lux, I think. Because if there's 0 trespass, it would be 0 lux.
Yep, I think you're right about that.
It's a no observable light at the property line,
Right.
I mean,
which is crazy. I mean, that's-
consider about this, and this only comes into play if somebody makes a complaint. I mean, if you have a light that's more than 10 lux
Yeah.
over your property line, and it's not.
No one's
bothering
going to
you,
enforce it. Yeah.
then no one's gonna enforce it.
Then we can see the other towns that we were able to look at here as well.
Wellesley, I think specifically was 5 lux for residences and 10 lux for quote other applications,
Yes.
undefined.
Yes.
And
we'll
interestingly, the Milton bylaw doesn't distinguish between residential and commercial.
Yeah.
There's no standard at all.
It doesn't seem to be. And
Well,
in
each
fact,
town
I
is
would say,
different too, right? Like, there will be towns that are very densely populated. It'd be really hard to force people not to have lights, but there are more rural towns where it's like large properties, I guess.
Yeah, like I saw Somerville was on the list of a town. I'd be curious, or a place that had lighting
Yeah.
bylaws, and I'd be curious what their standard is.
yeah, I didn't look at that one.
Yeah,
I think that
it seems like we're not at least stricter than any of the
We are. We're
Yeah.
twice as strict as
Way-
the next
yeah.
most
The opposite
strict
of
town.
strict.
What?
Yeah.
laxer.
What do you mean? Oh, okay. We're laxer.
5.
Yeah, right. Yeah. Depending on your point of view. Sorry. We're twice different than the next
Yes.
And
most
Hingham,
We allowed
Milton,
twice.
which is very similar to Milton. They're 2.7 lux at the property line.
Yeah,
which
so
is
that's
very-
quite low.
Yeah, it's so low.
Man, they get
Yeah.
So Nick, would you like to speak to, I mean, people are observing that.
Yeah, in my mind, this is a new bylaw for Milton. I think we should be more permissive. And if we need to, as a town, look to restrict it and increase the standards in, a year's time or 2 years' time, I think that's a lot easier than trying to become more permissive later in the future. It sounds like there are not a tremendous amount of issues. I think the great thing about this proposed bylaw is it does help, as Mr. Zoll talked about before, in the instances where neighbors can't get along, there's a third party kind of independent source of a referee, if you will. And I think in that instance, we should seek to be a little bit more permissive and start at a softer level. And if people think it should be restricted further over time, that would seem to be an appropriate action to undertake at that time.
I think that fits with the general approach of the select board to this, which has been to try to create something that's not too restrictive and not too prescriptive, and just create a process and then see how it works, and with the idea that we can come back and change it. But having something that's too strict and suddenly we're flooded with cases, whereas if it's too lax and somebody who complains and they're like, their neighbor doesn't fit the profile, then they can say, well, if we were in Hingham, they would fit the profile, so maybe we should take the Hingham standards, or that becomes a future argument. But getting something down that can start this process, I think, was the overall goal.
Yeah, I would just add, just because this says 2.7 lux for Hingham and Canton, we're not talking about what their bylaws have as penalties, right? Those aren't the same bylaw here. They can have a 2.7, maybe there's no penalty. It's just that's their expectation. So here we do have fines. This is a mechanism for potential disputes. So I think when Sean joined us maybe a month and a half ago, he did talk about an earlier version of the article had a lower level. And he probably, I don't know if he considered himself an expert, but I think we would all consider he's probably the most expertise, or he's the most experienced in this type of area. I think he had recommended we go to 10. So I would think that that's a more reasonable number. So
I also talked to Mr. O'Rourke about this one, and he also knows much more than I do about this. So yeah,
I'm not going to fight the 10. I disagree. I think it should be 0. Actually, I would agree to 2 or 5 because that's where the other towns are. I think 10 is too permissive, but I am persuaded by your argument that it's a new bylaw. Let's let the process play, and if we need to tweak it later because we're out of alignment, we could do that.
Yeah.
So I don't mind that argument.
there is.
Lee Michael, one other thing that came up last time this article came last year under consideration last year was that residents of East Milton Square had specifically indicated that due to sort of the relative distances to property lines, that and some of these laws would be really difficult to adhere to.
Right.
Without, and so I think short of having different rules for different population density areas, that I sort of agree that a higher lux level makes sense as sort of a single rule for the town.
Mm-hmm. Okay.
But they had expressed some serious concerns about being able to adhere to these lines and maintain even the most basic backyard light.
Just conscious of Mr. Zoll's time.
Thank you.
Okay.
I'm keeping an eye on it, but I'm here at the Warrant Committee's pleasure, so I'm happy to stay as long as you need me.
I'd love to have a
Oh, in that case.
quick check-in on the exception for the motion light while you're here.
Okay, you want to get to that?
Yeah, let's do that. So,
Or
there are
the
no
light,
slides
if we want to
for
talk about the light trespass versus dark sky, I think we agreed with that this is a light trespass article and not a dark sky article.
Yep.
And if folks in town are interested in having a dark sky article, that would be a different situation, and we could start that up. I know when we had our public hearing about this, there were a couple of kids from Milton Academy that did a very nice presentation on bird migration and dark sky, and that's not what this bylaw is about, but floating that out there for a future article writer. Yes.
I have a question. So we might be backtracking just a little bit, but this issue just occurred to me. So the person who's going to complain or try to enforce this article, does it have to be a neighbor, or could it be just anyone just driving down the street and say, oh my gosh, that house is so bright, I'm going to go and file a complaint or seek enforcement? So do you have to be affected by this alleged trespass?
It can be on state property or so.
Yeah.
No, I'm just wondering.
I think it's open to, and
Yeah,
if somebody wanted to file, they could file.
It's open to anyone.
Yeah.
I actually think, I'm not sure I agree with that, right? So there were 3 definitions, I only put 2 of them on the page in the article, right? So one is about what light trespass is, which is a condition with artificial light, eliminated from light on one property direct in such a manner the light source or glare is visible from any other property and constitute a public hazard or nuisance. And then public hazard or nuisance means lighting by virtue of its intensity, brightness, area of coverage, position, or direction causes adjacent property or occupants thereof visual discomfort or other physical harm or damage or substantial unreasonable interference with the use and enjoyment of such property. To me, that's about personal property, right? About light trespass and not about public property. And there's also a definition there about person. So I think you have to be a person and not an entity to have a claim of light trespass.
I'm going to share the relevant wording.
It's probably a good question for town council. I would defer to the town council.
Yeah, I'm just wondering whether somebody was just taking a walk around Turner's Pond. Could that person seek to enforce this article? Because, I mean, does that become...
Well, interestingly, we got a letter, right? I think you shared that with everybody. And I don't know if this is true. I didn't get a chance to validate that says you're not allowed to be in Turner's Pond after dark.
You're not.
Yeah, that's true.
So there's no light trespass if you can't be there and you're a person walking around Turner's Pond. That's an interesting observation.
The pond is being trespassed upon.
Sure, by...
As town
okay,
land.
but that's a dark
It's
sky
state.
provision,
It's
not a
state
light...
land, I think.
But not... Well, that was an interesting thing too. It's, I think, according to the Milton Town website, it's a Milton Park under the Milton Park Department, even though the state controls the fishing on there.
Oh.
You need a state, I think it's the state stocks the pond. I'm in the impression that you need a state license to fish there, but I'm not positive about that. So I think it's a Milton Park. But based on the concept of light trespass and not dark sky, we did remove 2 things from the originally proposed article that talks about visible from federal, state, or town land or wilderness or conservation area. That's more aligned with the dark sky provision. And we also took out, and town council did too, town trespass on the waters of the United States. So I think those are aligned with the intention of the article, which is light trespass, which I think is about infringement on personal property and people and not on public lands. Again, I think in my view, that would be a different, and Mr. Zoll mentioned that a second ago too, be kind of a different article with a different purpose. I'm not saying it's a good article or bad article.
Yeah.
I just don't sure those provisions would be aligned with this article.
Well, I don't agree with what you just said. The article originated to protect specifically the pond that we were talking about. So regardless of what kind of land it is, that was why the article started in the first place several years ago. And the words got moved into, it's at the third one down, which is now number 1, says light trespass onto residential use property, town parks, or state parks. We've replaced everything that you took out. So there's no change.
So then maybe that requires clarification then, because that again, the word person is not defined as such. And then the hazard has to be someone that caused discomfort. So how can you cause discomfort on a pond? I mean, that's like a dark
Wildlife.
sky. Yeah, but the wildlife wouldn't be able to testify to discomfort. If anything, I think everyone knew that there was a beaver that lived in Turner's Pond that was hit right on Brook Road this summer. So the argument could be made, maybe there needs to be more light to protect him. I don't know. I'm just saying. So I'm just wondering, like, I mean, it doesn't jive with the definitions of person, a hazard. So that's my.
Can I interrupt? We're getting deeply into this issue. I want to be respectful of Mr. Zoll's time. Mr. Zoll, do you want to speak to this issue, or should we skip ahead to motion detectors, which?
So again, I would defer to town councils on the residential use property, town parks or state parks, if that's a town council insertion there.
That was, I believe that was my
that was your
insertion.
Okay. I think you guys, we would have to discuss if you guys wanted to, sort of include town parkland in this.
It was in the last version you saw, wasn't it?
Yeah, and we had said that we were okay with getting rid of the dark skies provision, but then if the warrant committee comes back and says we feel like town parkland should be included, but not state park or American waterways or whatever the other ones were, then we would, I think take very seriously that consideration, but we'd have to vote on it.
Yeah, and I guess I would say if, someone is shining the bat signal under Blue Hills, that's a resource we all have. And to the extent that's damaging the habitat there or just making the park less enjoyable, whether it's open at night or not, I think that affects all of us, whether it's Blue Hills or town parks.
Actually one of the explanations that I read about 10 lux was that anybody experiencing 10 lux would lose their night vision when walking outside. So any person passing at the property line who's exceeding 10 lux is going to have difficulty seeing at night if they face the opposite direction. Mm-hmm. So anybody could be harmed by it.
Yeah, I disagree with what you just said a second ago, Jay, about the state parks and the town parks. I really do think this is about lice trespass, protecting individuals and their property rights, and not about protecting wilderness and wildlife. So I failed to observe that got put into what's now number one.
I'm sorry, I didn't try to sneak it
No,
past.
I'm not saying you are, I missed it. I don't think that should be in there. I think it should just focus on light trespass on a residential property.
I agree.
Problem is, if we make this sort of toothless as it comes to conservation land, then we're going to have a big problem in town meeting, because that was the original purpose of the article, as Lee Michael said.
Yeah.
So I don't know where that leaves us.
Well, it was, but then it was rejected at town meeting.
It never even came up at town meeting.
Well, no, but it was amended during town meeting over, and then it was pulled back because of.
It came with a huge green sheet and it got yanked.
Yeah, right at the last minute.
But I think if you go right to the beginning of our proposed article, right, the purpose of the article is to protect person from the intentional, unintentional light trespass caused by another person. And a person is defined an individual or legal entity holding title or using real property. So I suppose a park could be a legal entity, but I really don't think that's, I'm not a lawyer, so I know the definitions matter and all, but I really think this is about personal property and people and not wildlife and animals.
Well, we can take a vote on that in a couple of minutes.
Yeah,
right?
yeah, absolutely.
Why don't we talk about the
Motion
other thing
sensor
before you
stuff.
go, and then let's
Absolutely.
circle back to taking a vote on a possible motion.
So I know that one of the questions or concerns that I've been told some people have is about a motion sensor. There's an exception in the bylaw for motion sensors. I think it says 60 seconds. If the nuisance is 60 seconds or less, then
I
That's
scratched out
gone.
the 60 seconds.
Okay.
I didn't think.
So
now it just says temporarily.
okay. And so in the reading that I had done, the research I had done on the other towns I looked at, I did not find any motion sensor exceptions in any other town bylaws. I personally think it's a appropriate exception in the same way that, seasonal lighting is on the page as an exception as well, or landscape lighting and that kind of stuff. I think when you think about one of the reasons that people have outdoor lighting is to, walk from your car to your driveway, or you're trying to trigger something that, you're concerned somebody approaching your property. And so the motion sensor is there to protect you and provide safety for you. I think it's an appropriate exception. That's my perspective on that question.
I think everything you just said is true, except that the light doesn't need to go on somebody else's property. You wouldn't be walking in somebody else's driveway to get to your car. And no matter if something has a motion sensor on it or not, it should be shielded such that it isn't trespassing on your neighbor. Otherwise, that number 5, the way it's written right now, invalidates kind of the rest of the bylaw as long as it's on some sort of a motion activator. And a motion activator can be anywhere. It doesn't have to be somebody walking by. You could put a motion activator in your house and turn lights on and off that are outside, like
Sure.
this.
The chipmunks trigger mine, absolutely.
Yeah, right, exactly.
Right,
So
right.
it's just so
Not to interrupt, but depending on where you live, you're in East Milton or in a thickly settled neighborhood.
car going by all the
It's
time.
your neighbor's floodlight is going to hit your driveway. It will. It's just because of the way of the bulb, the lighting. So that's just point. I also want to point out there's a typo
Yeah.
in number 5. There's a
Parens.
parentheses. Yeah.
Yeah, it's
That needs to
as
be
virtue
removed.
of marking it up and redlining.
So you don't want a limit on like a 60-second, because what if somebody's floodlight stays on for
Someone, I think,
Going off. too,
Yeah.
all night long.
Yeah.
I don't think
We've
it should
had
be an
that
exception.
before.
I think you shouldn't trespass your light on somebody else's property on purpose, whether it's temporarily or permanently.
So I would just suggest, does the select board have a position on this?
We don't have a strong position on this one. I don't. We didn't debate it, so I have my own personal opinion, but I can't represent the select board on it.
I think we can vote on that one too.
Yeah.
okay, given that, do we have other questions for Mr. Zoll?
You can call me. You got my number.
When you're on the road?
Thank you.
Thank you, everybody, for
Thank you very much.
Thank you.
Really appreciate it.
There's another
Okay.
email.
So we are in the middle of 2 topics. Would it be too drastic to lurch back and forth back to I'll call it the wilderness park? All right, we can go back to that topic. And I will go back to the slides, because you put together a number of slides about that one. Okay, this is the first one. This is the first one. Okay.
I'm not sure I have other slides that I wanted to talk to on that.
I thought there were more than one slide.
There are some other slides. It's just kind of the language other towns had.
Okay.
So in terms of like trying to go through the issues that we identified that I thought different people had different views, I've gone from my perspective, shared the information that I've learned. I would say, as I said before, I've learned fast and furious here, and this is pretty technical language, and I'm not a subject matter expert. I've done my best to be as thoughtful as I can and as balanced as I can, and also share my perspective on these questions. So
Thank you for that.
Oh, you've done a great job.
Yeah, thank you.
The
Yeah, this is
the
really
slides
great.
are excellent. Information's excellent.
Okay, so can we focus on this topic of, I'll say we can, we have, as it is written now, and again, I didn't mean to slip it past you, but as it is written now, it's a violation if it goes on to, let me get the wording in front of me, onto residential use property, town parks, or state parks. Residential use property, town parks, or state parks, it's limited to 10 lux going across that line.
So I think it should be residential property at 10 lux and eliminate the state parks and town parks.
I agree. Leave that for the dark skies article. They want to do that.
Would it might be appropriate to have a motion to accept this as written, and then we'll discuss it, and then discuss an amendment of scratch out the town parks versus state parks.
Could do it in the other direction. It would be quicker, wouldn't it be?
If we vote on the amendments
Would be
first,
quicker.
isn't that what we did last week?
No, that is not what we did last night.
Okay.
How could we vote on an amendment if we don't have a motion in front of us?
Oh, right, okay.
Well, no, he would make the motion. I would like to exclude only, or have it
Include
only
only the
apply to
residential.
residences. And then you would change it, and that's what we would vote on. It's just, do it
I understand the
whatever way.
intent. I just, want to follow the correct process.
Can I ask some questions about this first?
You look at me like I know the answers.
Discussion, go ahead.
No,
Kim.
So I don't know if you guys saw the email that came out from, apparently, this whole bylaws based on one person's name.
I think
That's the,
Right.
I heard 3 houses are issues.
Oh, there are 3?
and their issue is security. That's how I read what his issue is.
In the email that he sent today to the
Right.
Warrant committee. Yep, that's what I read too.
Security.
Oh,
And he has issues with loiterers
right.
and people on his property, so he's trying to keep them. And he says,
Yeah.
doesn't this affect that? Like, does this make him less secure as a neighbor? Like,
It just
is
means,
that a concern?
So I would say that is a perfect reason why there should be an appeals process. And that's what we pushed for, so that somebody can make that judgment call. I don't think the warrant committee would be the right place to make that decision, because we don't know the facts. We're not gonna go out to look at his house. I actually live next to that house, but, you know, I think that's not our job to make a position. I wouldn't even talk about it publicly. I don't know what he's alleging, security or people behind his house, you know.
yeah, it also provides him and other people guidelines, of how they can, if they want to add, if they want lights for added security on their house, this is the way they can do it without, so that they don't interfere with neighbors or, depending on how we vote, town land, conservation land.
I would just say, I don't know the answer to your question, but I don't think we should allow people to illuminate parks from their properties. Your light should stay on your property. That's just.
Yeah. Well, unless it's a security issue. I mean,
No.
but then you have businesses that have issues too.
Yeah, like, where do you have security issues when you live up against the woods? I mean,
Well-
it's the woods.
Well,
You're not
he
going to
says people
illuminate
are
the woods.
trespassing.
Well, there are teenagers that frequently go there for various reasons. I've seen
Right.
them do it.
Is there reasons to break into his house?
I don't know about that, but again, I agree with Ron that we're talking about a very specific instance of which none of us really have the factual background to discuss. But I do know that there are teenagers that frequent that park quite a lot at night in that area. And they leave evidence of their activities in that park, because I walk around that park almost every day. So, but I don't know about this specific person. I didn't even know it was an issue until this article. But I'm just saying, like, there is security reasons. I'm living by that park, or even by golf courses. I used to have one behind me in Milton, and kids would go back there all the time, cut through the woods. Cunningham Park is another one, the pit. So I'm just saying, that's all I know about security. So there are valid concerns, I think,
Well, there
raised.
can be valid concerns about public safety, in my opinion,
Of
that you
course.
have to address
Yeah, of course.
without giving people permission to illuminate
Yeah,
an
of
area
course,
that
no.
they don't own.
Yep, of course. No, it's just a balance, I'm just saying, like, I understand both sides.
There's also something else to consider too. I mean, we're talking about this one house, but I mean, we've had complaints about like the Super Petroleum. They had this like, that super tall sign. The neighbors complained about that.
Oh, yeah.
The lit sign,
Yeah.
the Super Petroleum over in East Milton. This was a while ago.
I remember
and then,
that sign, yeah.
And then also the is it Eastern Bank? The bank that's in the Heart Dental building,
Oh, no, it's Rockland.
Rockland, it changes all the time. Yeah. Rockland Trust, yeah. There's a lot of neighbors that complain
Definitely
about that, but I'm not sure that this would satisfy
want
those
to,
people. I just don't think that.
Thank you, though.
If they come around full, I get to eat this.
Definitely.
Sorry, I'm taking one anyways.
So again, for the process, maybe I'm being a little dense here. I would like someone to make a motion to adopt the language as was sent around at about a minute before 7, and then we can make amendments based on that.
So I will agree to do that, but I'll just point out to you, then you're forcing people to agree to language that they don't want to agree to and hoping that they'll get to change that language later. So
I don't think I
there's
am.
an exception in there, right, for motion activation. I don't want that in there. So to have me vote on the article the way that it's written.
Not vote.
Oh,
move.
make a motion.
Move.
Oh.
To open the discussion.
Oh, God. All right.
Yeah.
Go for
Sorry.
it.
Now we're on the same page.
Yeah.
Okay.
Do you want to,
Do I have a
see
motion
what
in a
you're saying.
second?
go ahead.
We were letting the people who brought the
Yeah, I'll
experts
make the motion.
the motion, right?
Yeah, go ahead.
We're doing that? Okay.
I'll make the motion.
I'll make a second.
Okay. So we've opened up the discussion on the language as sent at approximately 1 minute before 7. I do apologize about that, and I'll do whatever I can to.
Should we note that James Lee sent in a text message or an email to the group that said that the town of Milton acquired Turner's Pond and Pope's Pond in the 1950s and 60s?
Nice.
So they're definitely town parks.
Yeah. Okay. Thank you. Yeah, I checked the Mass GIS today, and it's town-owned property. Okay, so we're discussing this, and I think it would be appropriate for someone to make a motion to amend, and then we can discuss that motion to amend. So let me
To further amend. And what we-
not further amend.
No,
No,
it's
just amend
as
the
written.
emotion that's going on. I'm learning, see?
That's awesome.
Amend the motions that put on the table to amend whatever the section is. Do you want me to give you this? 3B4, Part 1, to just say light trespass on a residential property no greater than 10 lux.
Okay.
Shall measure no greater than 10 lux.
Take out. My mouse isn't cooperating.
Take out onto, light trespass, take out residential property use, property, town parks, or state parks.
You want to keep residential.
No, sorry, right.
Take
You want
out
to take it
residential.
town parks and state parks.
You
Sorry,
want to,
I'm having mouse issues here.
you want
Yeah,
to
take
delete
town
town
parks
parks
and
and state parks.
Yes,
And the commas.
thank you.
I'll let Karen handle the comments.
So we're making a motion to amend.
Carol,
So there's a motion to amend, which we will discuss after it is seconded.
needs to move the yellow over.
I'll second it.
Okay, we have a motion, we have a second. So now let's discuss the motion to remove the phrase town parks, state parks. We've already been discussing it, but we can continue to discuss.
Yeah, I'll start then. I think it should be removed and save that for a dark sky type article, because this one's about light trespass on property, personal real estate. So to protect wildlife, that should be a dark skies article. So I support that.
I think if we were to remove that, we'd have to make it pretty clear in the comment that we removed it, and that this applies to
Of course.
residential use only, and not to
Absolutely.
town parks and state parks. 'cause
Somebody
otherwise-
will try to put it back in anyhow.
Yeah,
It's
they'll
on meeting.
most certainly amend, try to put it back in.
I agree with you, Macy.
I think I'm on an island here. I don't want people lighting up my town parks. They should be dark.
Islands are good.
I should be able to use my night vision and not be blinded by people.
You shouldn't be walking there.
Not
Says
this
who?
park, not that
Says who?
park.
No,
I'm sorry.
okay. Yeah, can I go then you?
Yeah, you go.
Yeah, again, sometimes I'm hesitant about expressing my opinion, but I'm 1/15 of the group, no more, no less. I agree with Lee Michael. I think this town is passionate about its parks, town parks and state parks, Blue Hills included. This town is passionate about them, loves what they bring to the town, loves the wild, I don't want to open the Pandora's box of what does life do to wildlife, what does light do to wildlife, but people are passionate about that. And I think this town feels strongly, and I think that was a motivator of this article. I think if we bring it to town meeting and don't address that, they'll wonder what we've been drinking on town land. And sorry, too soon. So seriously, I think this town is passionate about its parks. We're the keepers of the Blue Hills for the entire state, and I think this has a place. And now, who has grounds to complain? Maybe that's a question to be decided by the appeals board that will be created.
Also, it doesn't mean that you can't have security lighting on your property. It just has to be within certain guidelines.
Yes. Yes.
I mean, you can light up his yard all he wants. I'm sorry, it shouldn't. But a person could light up their yard all they want, direct all the light into their yard, onto their doors
With shades, yeah.
with shades, and you're good.
Or timers,
Yeah.
depending.
Yep.
So, Brian.
So this email from this gentleman, I don't know, but he mentioned, he referred to the people trespassing as criminals. Have there been issues like crime that's happened in this area? Because we're really talking about, does anybody know of anything?
No.
But is that pertinent to what we're talking about?
Well, security, it matters.
So I think-
It's a security issue.
In
it matters
town
to me.
parks at night? I mean, isn't that what we're talking about now, is taking out town parks or state parks?
Yeah.
Right, that's
Are
town,
we
that's
talking
town
about
park. You
security?
just got lights on town park.
Okay.
That's what
So I
his
think,
initiative is.
and I didn't write his email, but
I just
In theory, they're trespassers onto public land, and I guess that's a crime.
Yeah, I think that's what he's talking about.
Okay, I just didn't know if there was something I missed.
Oh, no, yeah,
That's
that it's a crime. Yeah, I get
That's
it.
the crime.
Right.
Okay, no.
I agree with Nick that I think this is a residential use article. I also agree with Larry that we should definitely put in the comments that we removed that phrase, because it's more pertinent to a dark sky article, which we anticipate, a group bringing in the future or whatever, if they are concerned about the very issue that we're discussing here.
I mean, our comments should inform the town meeting. Here's why we made our decision. Here's the information you need. When we say take out these words, I added these words last week, so we take them out. They never
No, but
exist.
the comment could say we discussed
Yeah.
trespass on a state park.
Yeah, and came to this decision, and here's
Right.
why.
The original,
Great.
the original proposed bylaw from the select board
You're right.
has a very similar clause.
You're right.
So what we're talking about now is just a reframe of that.
Mhm.
So I think it's a good thing to put to some degree in the comment. Yes.
No, for sure. It's a big part.
Ron?
I like on most issues, I'm torn because I do agree with you, Lee, Michael, and Jay, that I think the town, a good portion of the town, probably wants to see this. But listening to what our select board chair said, it sounded like he was comfortable limiting this article to just trespass for the time being, and focusing on what we have, and then not taking the further steps to go into dark sky. Did he say that? I think I heard him say that.
Okay.
Yes. Yeah.
Cecile?
I guess a question for Nick and Ron. So when you looked at the other bylaws from the other towns, did they specify like town land, non-residential town land, or parks?
I don't recall seeing that in there. My takeaway from looking at the other articles is that the Milton article is a lot longer and generally more detailed than the others. So that just stood out to me as I read through it. So there's, more exceptions, there's more details, there's more elaboration on the provisions. And I think partly because, I think the other ones are in the zoning bylaws. And so it's about, the construction of certain buildings. And, sometimes those bylaws apply not only to new buildings, but also retroactive buildings. Sometimes it just applies to new buildings. Some of them are explicit, like separate lighting bylaws. But I don't recall seeing that in any of the other bylaws. But I don't know how carefully for detail I read for that particular issue either.
Andrew, I see you, and then I have a couple things to say.
Thanks. I'm torn also, but I would prefer to give select board some discretion, because light trespass really happens all the time. If you think about street lights that are in town, they trespass on my land and into my bedroom. And I don't love it, but it's something that I deal with. And to the extent that you have some regional amount of light trespass or light spilling over onto town land or into a park within some degree of reason, I think the regional people can come to sort of some decent conclusion, particularly with the select board or whoever they appoint to hold these appeals. So I prefer to see some degree of discretion, but I understand arguments going in from both sides.
Okay. Thank you. So I'd like to, I guess two things. I'd like to read from an email I got from Rob Lavash, the chair of the Parks Board, and then bring up an issue of my own. Rob Lavash, I emailed him asking about this bylaw, and he says, it has been brought to our attention that one resident in particular has very large safety lights on the rear of his property, which intrude on Turner's Park/pond. While we have thought about other ways to mitigate the light spill, the resident has been non-cooperative. I think the bylaw could help in this instance. Is it a slippery slope, however, writing a bylaw for one particular nuisance? However, I am sure that it would help in other instances should they arise.
Yeah.
Don't know what we conclude from that, but I wanted to pass that on to everyone.
But he also said in that email, just for the purposes of balance, because I think you sent that to me,
Go
is
ahead.
that the primary concern of the Parks Department was about lighting of ball fields, which was, he said, adequately protected in the bylaw. And so that was part of what he said, but
Yeah.
to me, that was, had more emphasis than the one particular house that we've been talking about.
You're right. He did spend more time talking about ball fields. I didn't think that was relevant because
Just in terms of like, it wasn't his only focus of his comment.
True.
This is
true. Most of his email is about lights on ball fields.
right.
There's been a lot of complaints about ball fields too, but there's an exception. So, but
And then I guess my other comment is I'm stuck on this difference between dark skies and light trespass that everyone, I seem to be thinking of this differently than everyone else. For a dark skies bylaw, I think it's going to help me walk out and see the Milky Way at night. That's what I think of as dark skies. You can have a light as bright as you want as long as it's shining down. It's very different, and I agree that's not this. Light trespass is you're annoying people with your glare. So I think of, what is this intended to prevent? Even if we're talking about town parks or state parks, I'm not calling that a dark skies provision. It would be covered by a dark skies provision, I assume, but that's the problem there is the glare on people that want to enjoy the park. And I don't think the Blue Hills closes at night, not as far as I know. And so if we're casting glare on people who are trying to enjoy the Blue Hills, that's not a dark skies question to me. That's a light trespass question to me. Maybe it's subjective. But
I agree with that.
I don't agree with the distinction there.
I guess my rebuttal to that would be the beginning of the proposed article defines what the purpose of the article is, and it's about protecting property and not about protecting wilderness. And I think they're different intentions. And I think, the art isn't the definition. It all depends on how you want to define the issue. And some people can conflate the two together. And I think they're separate issues, and there's some intermingling of it throughout this article, and we're trying to create a little bit more delineation there.
The reason why I think many people would agree that town-owned parks are our property. As residents of the town, it's literally my property. But just because I don't have an additional property that abuts it, I don't think I should lose my right to have a dark environment or a quiet environment, whatever it is. The park shouldn't be altered by other people, and I think I should have standing because it's part of my town.
But I'm going to counter that because, so you can be part of the definition as person, right, under this bylaw. But then you have to show that there's a hazard to you, that it's a nuisance. So if you're not living there and you're just walking around the pond or just walking by, you still have those elements that you need to show in order to enforce it. And so I find that difficult, I think, because if I'm walking down Central Ave just on a walk, and yes, there's a lot of light, whatever, how is that hazardous to me? How is that a nuisance to me? It's a quick 1 minute and maybe 30 seconds just passing by. So that's my issue with like the state parks, not the state parks, the parks, the pond and all that. It's not coming into your bedroom. It's not glaring on your TV while you're watching, whatever you're watching. So that's the only thing that I have a hard time kind of differentiating. That's all. But,
Yeah, I think I agree it's public land and we all have a right to it, but some folks may like it dark and some other folks may like to walk around parks with lights on. I don't know.
As a woman,
like maybe walking around with a lantern and you would inevitably blind all the other park goers. But I think that's part of the deal of public land, right? So I don't know how I feel about it because I don't think when I look at the article, Nick, the purpose says it's about people, right? It's the purpose of this chapter XX to protect a person from the intentional or unintentional light trespass caused by another person. So I don't think the purpose doesn't really define the rules, but it is about people. So that makes you hesitate with that residential, non-residential. But I don't know how I feel about public land because I think you can have different uses. Maybe someone wants to have a big party. I don't know if you're allowed to do that at night. Then they would put lights up and they would blind other park goers.
No, that'd be temporary. That's why you have an appeal
Yeah.
process.
One of the exceptions.
This is something that
Exception too, right?
that we had talked about, Ron and Jay and I talked yesterday trying to get prepared for this conversation. And, there's a lot of, and we've talked a lot about it for an hour and 15 minutes, imprecision in this language that, I don't know, kind of makes me uncomfortable. And you could say that the action should be to refer it back to the select board, which would be for I think the third time. And that might not be an appropriate action, but I mean, all these things, the definitional issues and the technical details, they really do, kind of bring that up as a consideration. I think in the preponderance of my mind, currently there's kind of a dilemma that some people are feeling that they have no ability to seek recourse when they can't come to a neighborly agreement. And this provides them some recourse, and it's a start. And I think the flexibility that's afforded in it is kind of a good compromise. So the people that need or want recourse because they can't come up with a neighborly agreement have an independent standard to use for those discussions. And yet we're not kind of overly draconian about what's being proposed because there's sufficient amount of vagueness in it. So I think on balance, I think this is the right thing to do. But I do think it would be reasonable to sort of say, there's a lot of imprecision here. We've raised a lot of questions and it should go back to the select board for further consideration. So I don't know. I'm not making a motion. I'm just throwing out another input perhaps.
Can I ask a question? I mean, this is I understand why only 18% of mass communities have a law like this because it's so difficult. But what does this do to East Milton? You guys probably don't know. Is every house in violation there?
Well, yes, most of the houses are going to be in violation. And if somebody makes a complaint, it's going to go to that board and they're going to say, everybody in your neighborhood has the same exact violation, so there's no specific harm to you. Because the houses are so close, it is what it is. I think that's what will happen.
No, isn't it, if they're in violation, they're guilty? There's
Well,
no
it may not be a
can they say,
violation.
"Yeah, you're in violation, we'll let it go."
It may not be a violation because you have to look at the incremental light from the property. So if East Milton is well illuminated in general because of street lights, stores,
That's
and
true.
all neighbors,
Forgot.
you turn off one home, it may not have a 10 lux delta. So we don't know,
Okay.
but to Nick's point, we don't know. I mean, maybe 10% or 50%.
There's other things in the article that give flexibility for discretion and judgment of the person doing the inspection and making the finding. And then there's the appeals process where there could be extenuating circumstances. I mean, it really is not perfectly delineated exactly what it is, which I think is good, given I think the newness of the concept, because I think that's why it's not as widely adopted in Massachusetts as other things might be. And I think because it's difficult to define. And so, like I said, I think there are challenges out there people can't resolve. This gives them ability for recourse. And I think it's sufficiently broad that seems like the appropriate flexibility.
Can I counter that?
We are getting off the topic of the
motion.
wilderness, parks, etc.
So I just want to counter what Nick said, that definitions to me as an attorney, they're really important because they provide a roadmap as to what you can and cannot do. So yes, broadness is important. Vagueness runs into a little bit of an issue because if I'm the neighbor and I have lights all over my house, I want to be able to not violate this. So I need some sufficient notice and guidance as to okay, so where are my lights? Who's this person? This person who's walking by, how is it causing physical harm or damage? So that's the reason I'm questioning some of these definitions, because I would want to know what I need to do and what I can and cannot do. That's all.
Yeah,
So-
I think there are a lot of definitions, isn't there? And I think there's room for more if people
Yeah.
want to get, more detailed.
Yeah, so no, I just wanted to put that out there.
So again, we're right now discussing the motion to strike out the words town parks or state parks. I'm not trying to cut off discussion. I'm saying, do we have more discussion about this?
I've said all that I have to say.
Yeah.
Okay. Are we ready to vote?
Yes.
Karen, can you remind who's online?
James Lee and Andrew.
Okay. Sounds so. We are right now voting on the amendment to strike the words town parks or state parks. If you want to strike those words, you will vote yes. If you do not want to strike those words, you will vote no. Karen, can you call for a vote?
Just can you repeat that? I'm sorry.
Okay, if you want to strike the words, vote yes. If you don't want to strike the words, vote no.
Macy,
Yes.
Elaine,
Yes.
James Lee,
Yes.
okay. Grace,
Yes.
Larry,
No.
Brian,
No.
Lee Michael,
No.
Ron,
Yes.
Nick,
Yes.
Cecile,
No.
Jay.
It's not a tie, is it?
No, it's 6-4.
Okay, then I abstain. So
Me.
the amendment passes.
You got
Nobody
Andrew?
asked me.
Andrew?
Oh my gosh,
Andrew?
Andrew, I'm so sorry.
No problem. No.
Okay.
Sorry, yes. Confusing myself.
That's awesome.
To be very clear, I'd like to clarify what Andrew's vote is.
No, yes. No one, yes. Yes or no.
You want to
Isn't
strike
that
the,
obvious what I mean?
you want to strike the language town
No,
parks and
yes.
state parks.
Yes, I would like to strike it.
Okay. So that is 7-4. Is that
7-4 and 1 abstention. Yes, sorry about that, Andrew.
No problem.
I don't know where you went.
Yes. Problem.
Got it.
Stop saying
All
yes,
right.
please.
It's not even 8:30 at night. We're punchy. Okay. We were sort of drifting into some big picture philosophical questions, which were good. Unless we want to move on to.
Please take those commas out. Please.
Move the yellow all the way down.
Please take them out. I can't
Oh,
vote
no,
for that.
You're adding more. Everybody's OCD is going crazy.
Thank you.
One more.
That I can vote
No,
for.
one more. Yeah, one more.
Oh, you're right.
Yeah,
You're right.
one
Thank you
more.
very much.
Yeah.
Um,
Thank you.
Now, should we move on to the other discrete issue that we were discussing, which was
Motion sensors?
yes.
Dun dun dun.
If someone wants to make first of all, we're gonna,
I will make a motion.
by the power vested in me, we're deleting this parenthesis.
Okay.
Lee Michael, do you have a motion?
Yes. I move that we strike number 5.
Okay, is there a second?
Second.
Okay, so now we will discuss this. Lee Michael, would you like to start off the discussion?
I think that motion activated lights are great and that people should have them in their driveways. And I think that they can be shielded such that they do not illuminate their neighbor's property. There's no reason to have an exception for a motion light that says, as long as it's temporary, yes, you can trespass any unlimited number of times onto my property that you want, because it's not like it says it can be 3 seconds. It's not says it can go on twice a night or something like that. It can literally go on and off all night long and light up my yard like their driveway.
Yeah. I had a neighbor that had a light like that. It was like a strobe light in my backyard. It wasn't bad. It was only when I was in the backyard, but you had people over, whatever. It was very irritating.
Can I ask what? So what if that motion sensor is right in your bedroom and just keeps flickering all night?
I had that.
Exception, and that was in
I had that exact scenario on Brush Hill Road, where the houses are pretty far apart.
yeah.
I from 2 lots away, it illuminated my bedroom.
Oh my goodness.
That's crazy.
What? And so like cats would walk by or birds would fly at night and it would just constantly go on all night long.
I don't see any other hands, so I'd like to say something. So to me, this has the same feel as the 10 lux versus less than 10 lux question, which is to say right now, September 29th, 2025, all of this is legal. It's all allowed. So we're trying to decide what are we going to change the law to forbid this? And just like, maybe 10 lux isn't perfect, but let's be a little permissive to let people get, find out where we are with this
Okay.
and take out the worst of the worst. Similar here. I keep thinking of a healthcare worker who works at the hospital until midnight, comes home, wants to park in the driveway, and wants to be well lit when they walk in their house. And I know I've bought motion detecting lights from Home Depot, and I cannot for the life of me figure out how to adjust their sensitivity or the time.
Oh, yeah.
And I may not even be able to adjust the angle. That's how hopeless I am around the house. But again, if I were a healthcare worker who got off shift at midnight, I would not want somebody telling me I can't have an illuminated.
Neighbor's yard.
Yeah, you know, spilling over into the neighbor's yard.
Okay.
Ron.
I have two comments. I agree with you. This is a new law. I would take baby steps. And so for me, the more exceptions, the better. We can decide later on if we want to remove the exceptions. But I would say if people have motion sensing lights, I would say let's not tell everyone they got to take them down. Because I think every floodlight is going to be very bright and it's probably going to go over someone's yard. So I would be cautious about removing this one. The other thought I had was if I think about what I feel is reasonable, let's take, for example, if there's a person who owns a property and they're concerned about their safety and they want to shine very bright lights in their backyard because they think they're criminals or trespassers, I would say then put them on a temporary motion light. And that's maybe a compromise as opposed to shine that light 6 hours after dusk. I know that that's without talking about that specific case. I think that's a reasonable solution to say shine it for 50 seconds and turn it off, because if no one's back there, there's no reason to have a light shining back there. But if someone is, maybe that's sufficient safety. So I would keep that because this gives that kind of like reasonable option that you can have bright lights, but just don't have them on, without a reason. So.
Can I ask a question to Ron?
Sure.
Do you think it would be better, this clause, if you put in a specific time limit, such as 60 seconds?
Yeah, we talked about that, and we just weren't sure what the motion sensors are. I don't know if you can control them or.
Ron put those numbers in there, and I took them out again because I'm incompetent. I wouldn't be able to make mine.
I have
be
one in
less
my
than
yard
60
too.
seconds.
I eventually just disconnected it.
Yeah, I have, one of my houses, we have motion sensors in the back. We don't have, I think 60 seconds, like I said, I have a big backyard that you can park in, and then you have to walk up to the side of the street. So to get into the house. So I don't know if 60 seconds would be enough. And so I'd rather just leave it vague, short term to see. But I do agree with maybe turning down the volume of the light, to your point, because that's horrifying to have somebody's light in your bedroom all the time.
Right.
So as long as it's below 10 lux, it wouldn't be a problem in any case, correct?
No, this is an exception though.
That's true.
It can be as bright as it wants to be.
This could be above 10 lux.
Oh, okay, yeah.
Yeah,
So we're saying-
that's what the problem is that if these kids are hanging, I don't really want to reduce this to one homeowner because this is for the town. But if you have a nuisance problem and, there are people constantly wandering around your property, those motion sensors are going to go on and off and on and off. And it's going to be, in some ways,
More annoying,
worse
yeah.
than if it were just on steadily.
You get surprised by it, yeah.
Yeah.
Right, but in the case where my house, it's only me coming in the backyard.
Correct.
So then I wouldn't have an easy way to walk to my doorway.
What if we said something like 5 minutes?
That's reasonable, I think, or even three or five, something like that.
I think if we say temporarily, and if the person goes out to inspect it and the defense is, oh, it's limited to 1 hour, they're not going to get the exception.
You don't need an hour limit.
Yeah, I
4
think.
minutes is enough.
Yeah.
It just depends on, if doorways.
I think
6
temporarily
seconds, back door,
implies
3,
However
a couple
long
of minutes.
Yeah, reasonable. Like however long you would need to reasonably get
Right,
to
to
your
get where
door.
you need to go. Safely.
60 seconds for you.
I'm not going to die on this hill, but I think temporarily, everybody knows what a temporary motion activated light is. I see Ron, I see Brian.
Mine's real quick. I don't know that a light going on and off is worse. I think that's subjective because I may say I like it going on and off, so I know someone's there. Because if it's on all the time, I have no clue. It's just on. But if it's on and off, then I know, okay, someone's walking around behind my house. Maybe I call the cops. So maybe that's better. I think to say it's worse, maybe that's overgeneralization. So.
Brian?
Yeah, I think people only put in motion detectors for safety reasons.
Yeah.
Whether someone's, I don't think it's necessarily breaking in, but just seeing, getting into the house. And I think that, and I see them, I walk my dog and they go off, sometimes just walking the dog, but I think that you could irritate a lot of people in the town, who all of a sudden put in a motion detector that they put in for safety, and now you're saying, no, we want you to take it out, or we want you to look at it. I think it could cause a problem with this whole thing.
Yeah.
Should we vote?
Is there further discussion?
I just think if this is the exception and that it can be as bright as you want it to be, then it really takes the teeth out of what this bylaw is trying to do.
Yeah.
I will throw out there, just for discussion, the people who want this struck, would you feel different if it did have a time limit of, let's say, 5 minutes?
There would have to be a lot.
But
It would have to say it can be on for no more than 2 minutes, not continuously for whatever. It can't come on and off every 2 minutes, right? So it would be a little more complicated than that. But yeah, if there was a limitation on it, I would feel much better about it.
Me too.
So I'm looking at my floodlights right now. No, so I have them, and this is not the one. This is not my house in Milton. It's my house, Provincetown, and I have it. The limit on this, and this is obviously on an app. It's 5 minutes.
Okay.
The floodlight. So I can't even put this on for 10 minutes if I wanted to. It's 5 minutes, and then I can reduce it. So just as an FYI, and this is obviously a modern, more modern system than just the one you go up there and you turn it. So, and I'm thinking about the one that's over my garage in Milton. I think it's a 3 minute limit because it's a dial. So you can't even have them on for an hour. So that's just as background if you want to put a time limit.
Would the people who want to make this amendment prefer, instead of scratching this out, adding, and maybe prefer is the wrong word.
I would prefer to leave it like this, and if somebody wants to then make a separate motion, I would consider that.
So the motion before us is to
strike 5.
Strike this clause. If you want to strike the clause, you will vote yes. If you want to leave the clause, you will vote no. Does everyone understand what we're voting on?
Yes.
And I see no more discussion. Karen, can you call roll?
Macy.
Well, that's a really hard one.
In my day, it was everybody put their hands up or down at the same time, so there was less pressure.
Can you skip me? I want to think about this because there's really good points.
Okay, Elaine.
You want to see how the rest of this goes?
But you made great points.
I can go first.
There's some juice in those.
Yes, I believe it should be struck, so yes.
James Lee.
Abstain?
Grace.
No.
Larry.
Yes.
Andrew.
Yes.
Brian.
No.
Lee Michael.
Yes.
Ron.
No.
Nick.
No.
Cecile.
Yes.
Macy.
Is it a tie?
It's right now 5 yes, 4 no.
We still haven't got everybody, right?
Everyone made excellent points. I'm having a really hard time with this one.
If you make it a tie, you make it Jay's problem.
Call Andrew.
What's the tie again?
Oh, yeah.
5 yes, 4 no.
Did you do Andrew?
I did do
I
Andrew
already
this time.
voted.
And
And I
James Lee is an abstention.
And I didn't say yes.
All right,
now,
I'm gonna say
so-
no and leave it to you.
Okay, you're going to say no.
A
It is a
tie.
tie. Well, whether I abstain or vote no is the same. I will vote no.
Ah.
The motion does
Thank
not
you for your
carry.
feedback there. Do we want another amendment around this
For time,
around this
limit?
line?
I haven't done enough research to feel comfortable
Okay.
knowing what putting a limit on it right now would
And
do.
I will say, while I don't love green sheets that wholesale change
Right.
things, if we came to town meeting and said, hey, we want to add this little clause here,
Yeah, we could do
that's
that.
not the end of the world. Ron?
Lee Michael.
Yeah.
We could add a reasonableness
Yeah.
clause there. It will immediately push it back onto the inspector.
Yeah.
We'll then have to take it, it'll go to the appeal to make a determination of what's reasonable.
Yeah, I like that.
Yeah, I was gonna suggest that. Reasonable.
Okay.
Can you suggest wording? Ron, you're the lawyer I'm pointing at now.
So it says,
Oh, you want me to make
oh,
it
no,
bigger?
no, no, I had LASIK, so I can read this. Get my money's worth. A motion activated luminaire that does not unreasonably cause a nuisance.
We
I'm
can call
thinking
it
a
reasonable
reasonably
nuisance.
motion activated. Or
Yeah, lawyers will go double negative on you.
Oh, that's great.
What
that
about
But it's so vague. I mean,
causes a nuisance for a brief time, like scratch the word temporarily.
Does
Causes-
not-
you could do this, a motion
Briefly?
activated luminaire that temporarily causes
How about that does not cause undue nuisance?
yeah.
Yeah, that sounds better.
Or you can say that
does not
Yeah.
unreasonably
Because
cause.
it's going to be, this is going to be,
unreasonable or for no longer than necessary.
I mean, that's,
Because
you know,
reasonable is
if
the
we say
standard.
5 minutes, I can know if I'm in violation or not. But if, otherwise I don't know if I'm in violation or not.
How about unusual? Motion activated luminaire that causes a nuisance, but not an unusual nuisance, or that.
how about does not cause a nuisance, right? No, that's a
I don't know if
judgment
you can
call.
do that.
Temporarily
Causes.
Temporarily causes a nuisance, but not continuously, or not, I don't know.
Or no greater than absolutely necessary for safety reasons.
Oh,
That's fair.
Yeah, it temporarily causes a nuisance, but reasonably provides safety or something. Like, because reasonable is the standard language. It's the reasonable person standard. If you can put it in there.
that
somewhere.
temporarily causes a reasonable nuisance.
Moderate or modest.
Isn't that what you're
I
saying?
want to say unreasonable nuisance.
Isn't that what you're saying now?
Because nuisance is not reasonable.
Causes a nuisance
Ever.
for a
Right?
Huh?
There's no such thing as a reasonable nuisance. Because then it's not really a nuisance, right?
Well, it would be one that's
Unreasonable.
usual and customary. It's
I'm
a
liking-
nuisance
I'm-
that you
I'm liking the
that
5
you're
minutes
used
more
to.
and more.
So you can say an unreasonable nuisance.
I'm
Right.
liking 5 minutes more and more.
I agree.
Yeah.
Okay.
5 minutes.
If you're gonna put something-
Limited.
That's why the experts had suggested a time limit.
That was you, right?
Original. Well, there are two experts here, so.
That was all you.
All right, so
No, but Lee brought up a really good point. Lee Michael brought up a good point about that this does give them, you could have a very bright light rather than sort of a reasonable amount of light. So I don't think the time necessarily gives us what we want. It's more about what would a reasonable person say is a good level of light for this particular security or sort of exception that someone's looking for.
I hear what people are saying. I'm trying to think, how are we working towards a suggestion for town meeting? And 5 minutes we can put our teeth into. The other things that are being talked about, I'm sorry, I mean, we should put the amount of time into this that is required, but I don't know that we're working towards a solution.
The thing about 5 minutes is that it opens up this whole can of worms as to how many times in
I
a
was about
row
to
can
say
the
that.
5 minutes be.
And I don't think there's any way to solve that.
Yeah, intervals.
If you've
or-
got raccoons going by all night, you can't solve it. That's what it is.
But then, well, no, we just
Yeah, and
voted
so
it
a
down.
reasonable nuisance, limited nuisance or.
Yeah, limited nuisance.
Limited nuisance. That
Okay.
sounds great. I like it.
Motion
I-
activated.
One other thing we could do is talk about the nuisance is incidental to the safety benefit. That so if someone's not just directing a floodlight onto
I'm
the
not
neighbor.
pointing at your bedroom.
If it spills over, maybe that's incidental and maybe it's okay. But your primary purpose should be for safety on your own
Yeah.
property.
I like
I like-
limited nuisance. Limited nuisances. Incidental. Would you
I like
do an incidental and limited nuisance? But otherwise complies with this bylaw.
Yeah.
Limited is better than the 5 minutes.
Yeah.
Yeah.
Okay, I'll
That's
scratch
what
I like that.
Yeah,
I like
I
it the
take
way
out the
that.
time.
This is good.
Yeah, and
You're
take
right.
that out. Jay,
Do
I
we
would
need
delete.
incidental?
You should delete everything after the word nuisance because but otherwise complies with this bylaw creates a whole can of worms.
I agree.
Yeah, fair enough.
That was original language, not introduced
Yeah.
by the experts.
Yeah,
That's a
that was
pro-
amateur language.
That's a problem.
Yeah.
Take that out.
Okay. All right. Do I hear a motion?
I would like to make a motion that we add the words incidental and limited as shown and remove but otherwise complies with this bylaw as shown in red.
Do we have a second?
Second.
Are we okay with moving to a vote?
Yes.
Karen, can you call for a vote?
Macy,
Yes.
Elaine,
Yes.
James Lee,
Yes.
Grace,
Yes.
Yes.
Larry, Andrew,
Yes.
Brian,
Yes.
Lee Michael,
Yes.
Ron,
Yes.
Nick,
Yes.
Cecile,
Yes.
Jay.
Abstain.
The motion carries.
Yay! Thanks for making that suggestion. That was awesome.
Great.
Worked great.
Okay. Okay. I'll turn to you, Nick, leading the discussion. What other items did you have on your list of? I can look at your PowerPoint even though nobody else can.
I think we covered it.
Appeals, brightness, light pollution, etc. Motion sensor, fine amounts.
Oh.
Do we have anything to
it's-
discuss about the fine amounts?
Is it, so it's 300 flat now, and it was
It
there was
is.
some discussion about going graduated from 100 to 200.
Oh,
You know, I do think this is one of those things where there's a lot of vagueness in this. So if you think about it, you can make a complaint. It may take, like 30 days to be investigated. And then you have 45 days to have an inspector come out and inspect. And then you have an appeals process. And only then could you get started and get fined $300 for each violation, which says every single day, but you have to have a complaint to have an individual violation. So there's, it's $300. It seems like a lot, but there's a lot of days and times and steps that have to go through before you get to that $300 fine.
I have a question about that. In order for it to be a violation, doesn't that have to be decided by the 3-person committee? Because a complaint is one thing, right?
So if you have a complaint, then it has to get investigated. Then you have 30 days to respond, and then you could, as part of your response, you could request an appeal. And so there's a lot of steps and a lot of time that could go before
the $300 kicks in.
Yeah.
Okay.
For the first 300, I mean, I'm going off memory of a conversation I had with Mr. Milano, because I asked him, I said, like, okay, you go through all this process, you get your first $300 fine, and then is it, 20 days later, they're going to say, give me $6,000, or do they have to ensure that you are violating every 20 days? And as I recall, what Mr. Milano said is, it'll be the $300 fine. They'll have to go out and measure you again if they want to fine you again.
Right.
That didn't imply that it had to go through the whole, what are we at now, 90-day process? He didn't imply that, but he did imply it won't be automatically every day. It'll be, oh, we fined you last week. We hear you still haven't fixed things. Okay, we're going to send somebody out next week to measure you again.
Right, but I just turn off, as opposed to a building code violation where the remedy might be time consuming and expensive.
Mhm.
Here, I just have to turn off the switch. So I can turn off the switch and 30 days later, I could turn it back on. I complied and, you could monkey around with this quite a bit. I
Yeah.
think there's a lot of flexibility, loopholes in the application of this. It comes back to what we talked about before. There's a lot of imprecision in the bylaw.
Grace?
Yeah, I just have a question because it says each day such violation continues shall constitute a separate offense. So what Macy was saying, does that mean like I've got a definition that I'm in violation on Monday and I still haven't done anything Tuesday, Wednesday, Thursday? Is it $300 every day, or is
Yes.
it when they come back out? So
No.
that's like $1,200 in 4 days.
Yeah.
Yeah, as I read it, it would be every day, but what Mr. Milano says is, no, they'd have to go out and measure it. So how often are they going to go off and
So then
measure?
that language would
But there's
probably need
still
to be
a
changed.
But
Yeah, it needs to be-
but the
well,
point,
no.
but if they measured it every day, it would be
Yeah.
$300 every day.
Yes.
Yeah.
Right.
And
Yeah.
yeah,
This has to be each violation, so it has to be per measurement.
Right. The violation wouldn't occur if somebody doesn't measure it.
Yeah. Right.
Right, but that constitutes that initial measurement, not they're coming out every day to measure every day.
They could come out
They
every day.
could, right.
Which you kind of would want, because if somebody put up like a billboard or something or a light that, and it was a real problem, you don't want them paying $300 and like getting away with it for 6 months. You want the town to be able to escalate to the point where it's punitive.
It can't be 3 times in one day. Right, so that's why you have this once per day. There's
No, I just
measurement.
wanted to be sure, because what Jay
Yeah.
had said was different, so I wanted to be sure we understood that.
And then my other question is, when do you pay? So, for example, so you're finding each violation each day, right? And you exercise your right to appeal. So you appeal it to the 3-person committee. And does it get stay, the fine, when you file an appeal?
Question.
Or does it continue to accrue?
Yeah,
So it's
let's.
accruing at appeal, or it's accruing?
Yeah.
at-
I heard the word
To appeal.
stayed, which I had read today, or was it?
So those are
Stays,
different.
there's not many depends denied. Authorized. I don't remember seeing anything about it being
Um,
stayed.
So Macy, you were saying that
we should probably
it
add something about
starts
that.
at the appeal where the clock starts in terms of the violation
think-
cost?
It's from
Toll.
what
Decision.
I think it sounds like the moment they go out and measure you, and you're considered
Oh, regardless
violated.
of.
Yeah,
But
then
you
you
get
have
the
$300.
penalty.
This is the word that sounded like a legal word. Toll. What does that mean,
Toll
Macy?
findings.
Yeah, it really should.
I
be-
assume I know what it means.
That's to collect.
Yeah, told me is like it's also stay. It really
Yeah.
should. The
I think
appeal
that's what it
shall stay findings and continue on to 30 days following the conclusion of the appeal.
I
So it looks
respect
like-
you, but this is wording from our town council. So
Toll is usually a time for filing an appeal. Like time is toll. I don't know. Toll stay is the same, but I prefer stay. That's mine. I don't know, Ron, do you have an opinion
Stays
on
fair
that?
to the average
I like
person.
the
I would
word
leave
stay
it.
better.
Yeah, I mean, it's kind of weird language, but I would leave it with the council.
Yeah.
He proposed this.
Toll findings
He or
and
she.
continuing violation. So it looks like
To
an
toll means
appeal-
to suspend or pause,
Yeah.
particularly in legal or regulatory contexts.
Let's stay
There
for
you go,
continuing
fair enough.
violation 30 days following the conclusion of appeal. Appeal within 30.
So the appeal essentially doesn't do anything unless the decision is against the person.
Mm-hmm.
Can we make sure that that's in the comment?
What?
I don't know, like the comment, just that's clear. Because most average people don't know that toll means stay.
Oh,
I don't.
I'm not a lawyer,
Violation of 30 days direct
I don't know.
Hmm?
I don't know that needs to be in the
appeal.
comment.
Okay.
Oh, just,
Mm.
yeah. I mean, we'll probably talk about all the things we've talked about tonight, right? Like the appeal
So-
process.
Yeah. Oh, sorry.
But it doesn't toll until after 30 days. Okay, after the conclusion of the appeal. That language is shall toll findings and continuing violation until 30
I think this is a good thing
days.
to check on with town council, and if we need to switch it around, we can do a green sheet on switching the wording around.
Yeah, I mean, this is town council's
Right.
wording.
So I suggest not changing that particular sentence.
Yeah.
Following
Yeah,
the
just
conclusion of
letting
the
people
appeal,
know how does the appeal
toll
affect
finding,
the time.
continuing violation.
So there's no amendment proposed for the appeal
So,
process.
I mean, my
That's
questions to
fine.
town council were about the appeals process. I had one other thing, but then I had a general question like, is this a workable bylaw? And I don't think they answered yes or no, but I take that to mean they would have said something if this was just an unworkable bylaw.
Well, lots of towns have them, so they have a lot to compare it to,
I'm just concerned about the when it starts charging people and the accrual process.
I think it's
That-
after you lose your appeal. I think
Okay, so that's different from
Yeah.
what Macy was saying.
Well, it
Is
looks
that-
like you
This
accrue
is why I
it.
want to be sure that people understand that.
So it looks like it continues to accrue with each violation. So to me, that means each measurement, right? So every time they come out, they find that you violated. Because
but-
my question is like, somebody comes out and measures my lights, right? And they find me in violation on, let's say yesterday.
Yeah.
No, today's Monday.
Correct.
And then tomorrow, nobody comes out and measures to see whether I turn it down. Am I still in violation or not? I don't know.
if the town sends somebody,
Yeah.
they could find you in violation again.
Yeah.
Your options are to pay within 30 days, I think,
Mhm.
or rectify within 30 days.
Right.
You don't have to appeal. You can just say, yeah, it's
Right,
shining
but so
light.
in the appeal, I mean, generally the appeal process is to try and stay that so that you
Yeah.
can then have a decision that prevents you from having to pay, right? So that's why it's interesting that the accrual starts there
Yeah.
as opposed to the decision at the appeal.
Right.
But it's
See my
not
point?
due. They don't have to pay it until the appeals process renders a decision.
And it's not necessarily every day.
It's like
They would
fighting a
have
parking ticket.
they would have to send someone out every day to find each violation. So I read it to say it's $300 for each violation. So you have to keep,
And then those are continuous violations.
if somebody comes out and keeps finding you in violation. Because that's how,
I would,
I would argue that,
It's administration.
Right? I mean,
has-
let's
They're
go
gonna
back.
Stay the findings of continuing violation until 30 days following the
Right.
conclusion of the appeal. So,
Good point.
but
Right,
go
so
back,
right, so they're gonna stop it.
It's paused.
Okay.
Yeah.
So it's only one violation.
Yeah, but there is a violation and you are
Appeal, yeah.
causing a nuisance until the appeal decides
Yeah.
But if I'm
otherwise.
in violation January 1st, they can't then say, I'm also in violation January 2nd, 3rd,
But
4th. They have
keep
to
that-
wait till all this is done.
If you file an
Oh, you
appeal.
have
Yeah,
the
but
30
but you gotta go
days,
back
right.
up because it says for each violation. That was the language that I saw.
Go back up. Wow.
It's actually down.
Oh,
It's
Yeah,
lower.
it's down, yeah, so, okay.
It does say each violation,
Yeah.
but that previous sentence accomplishes what you want it to do, which is it limits it to one $300
I-
violation.
I can't get my second violation against
just
me till
think
after the whole appeals
violation.
process is done.
Calculation of what people are gonna be
But
owing.
it doesn't.
Clear.
It says each
They're aware
day
of it.
such violation continues shall constitute a separate offense.
Those
And I
seem
think
like
that's
Unless they
starting
appeal.
After
Yeah.
everything's done.
you
after the
appealed,
appeals.
and if you're still in violation after the appeal, you start owing $300 a day. But during the appeals process, you're not
Okay,
continuing
that's
to.
what I wanna be sure,
Yeah.
because I don't know if that really
Yeah,
says
that's
that, but if that's.
Yeah, or if you don't appeal, you decide not to appeal, then the inspector can
Yeah.
come out day 2, day 3. I think if you have time to read it, I think we just haven't had a chance to read this and we're
Yeah.
just kind of all reading on the fly. But
Yeah,
Mhm.
I think it's okay.
I think it's fine too.
I don't have any
And-
emotion about it.
I am a little confused about what constitutes a violation, or that whether it's a measurement or the language here says each day. Doesn't say that it has to necessarily be measured that day. So which is the sort of superseding definition of?
Somewhere it says here that it needs to be determined if there is a violation. So it uses the word determined.
But it's each day such violation continues. So to determine a violation, you'd have to have an inspector go out.
There's a comma there. There should be.
Is there a superfluous comma?
Yeah, right there after possible.
I see. I don't think. I think you're looking at my screen. I think Karen has the master copy. So,
Okay.
but I don't want to cause anyone agita. I don't know where the.
Paragraph 9 after possible.
The underlined bit.
Yeah,
Oh, okay.
there you go.
Wrong word. Okay, so getting back to business.
Hmm.
So we're 100% clear that a violation only occurs, or a fine essentially only continues to toll when someone goes out to measure.
It's not that easy to say. So what I think the bylaw says is that if you are found in violation, we can fine you $300. You then can appeal that process. At such time that you appeal it, $300 fines get suspended for the amount of time
Yep.
that you're appealing. And then if the appeal goes your way, your fines are nullified. If the appeal doesn't go your way, then the town can start assessing you up to $300 per day after such time as the appeal is decision.
Okay, I understand that. That's
So in other words, you want to appeal as soon as you get that violation.
Right.
Yeah, that I think,
Okay.
I can understand that.
But they
if
have
you
30
don't-
days. They have 30 days.
But if you don't,
Yeah.
I understand that piece, but if you don't appeal, does a fine accrue only each time someone goes out and measures it, or?
Well, it says right here under penalty absent an appeal. So if you don't appeal, person found in violation
Yep.
shall have 30 days to correct the violation, after which each additional day during the violation exists will constitute a separate offense. So
Whether or not it's been measured.
yeah,
By a
it
town.
doesn't matter. You don't have to be measured. So if you don't appeal,
Nick,
Which
30
is
days.
different than what Mr. Milano told me, but I mean, there's what's written and there's what he told me. So
which each
Yeah, and so I'd love to
He's
see
here.
clarity around that.
okay, Mr. Milano is with us. Is he a participant? Can he speak?
Somewhere else in here, it says something about it needs to be determined to be a violation.
yeah.
And in order to be determined, it would have to be measured, or somebody,
That's what I think.
or somebody would at least have to come and eyeball it and say it's the same brightness as it was yesterday. It's another fine. You know, it might not require 4 hours to say, oh, obviously nothing's changed.
Karen,
The
can
4 hours
Mr.
is
Milano speak? Is he
Right, so
promoted?
you still have to pay him.
Nick is a participant,
Is the
yeah,
what?
he's here.
Minimum.
Union minimum.
I mean, he's logged on, maybe he's walked away, but I.
Yeah, Mr. Milano, are you there? Are you able to join us and speak?
He may have walked away.
Okay. 2 children under the age of something very small. Okay.
It does.
Well, I mean, there's no motion to amend. I don't
No,
think.
there's
No, we're just.
no motion to amend. We're just
We're out of discussion.
making sure
Yeah,
we're
right.
comfortable with this. We still are discussing the main.
I don't think there's
Be clear
anything.
about that. Yeah, I mean, we could wait a few minutes and see if Mr. Milano reappears. Do we have specific?
Do we have any other
Well,
business?
I'll put it this
tonight?
way: Do we have any other business tonight? Did you say? No.
Yeah, we're not going to vote on the comments, right? That'll be.
We're not going to vote on the comments. Yeah, I might discuss the comments a little bit. Discuss when we're going to meet next. That's the only other things. Yes. Oh, and minutes. We could vote on minutes tonight.
I didn't submit new ones. Did you vote?
Oh, we still have ones from a couple weeks ago.
Oh, okay, cool.
What's up, Ron?
So if we wanted to, we could do an amendment that would make this language more in line with what Mr. Milano explained to you. It could be as simple as on the second line of that last paragraph, the paragraph that starts a fine of $300, blah, blah, blah. The second line says each day such violation continues. We could say each day such violation is determined
Oh, there you go.
Okay.
shall constitute blah, blah, blah. So we just replace continues with is determined, you can say is determined by the inspector, inspection department, whatever,
It's determined by inspection.
or their representative. I think there's some,
You could just say redetermined because it's already been determined once.
I agree.
The word.
Yeah.
Right.
And again, if town council wants to tweak a little bit, that's totally fine.
Yeah.
Great.
That sounds good.
Do we need to vote on that?
Well,
I accept it as a friendly amendment. No, I
no,
don't.
we've got a motion. We've got a second.
On the amendment or just on the?
Sorry, of the amendment only.
The red and the
Remove the
green.
word continues and adds the word redetermined. Each day such violation is redetermined to constitute a separate offense. Karen, can you call roll?
Yes, if you give
for a
me
vote?
1 second just to
Sure thing.
make
Can we,
sure I
can we
know
ask
what
if there's
you're
any
doing.
no's? Because it's probably might be unanimous.
I don't. I think with the remote meeting, when everybody's here.
Oh, it's good. I thought that was my phone. I was like,
No, it's telling you to go.
I like hearing everybody's name.
It's a great
Yeah.
noise. It's a great
I
noise.
know. I was like,
Just makes me want to lay down.
I'm ready.
Okay.
Macy,
okay, so yes is to do that language.
Mhm.
Yes.
Elaine,
Yes.
James Lee,
Yes.
Grace,
Yes.
Larry,
Yes.
Andrew,
Yes, no.
Oh, come on.
Yes, yes.
yes, yes. Brian,
Yes.
Lee Michael,
Yes.
Ron,
Yes.
Nick,
Yes.
Cecile,
Yes.
Jay,
Abstain. Okay.
motion carries.
Mr. Milano, are you with us? Okay. We have the entire motion in front of us for this article. Are there any other questions about the final wording? Again, I apologize for the late dispersal, but I think we've looked at everything that's been changed of substance that you've seen before. There are 2 periods there. Is there any more discussion about this article? Okay.
Yeah. I'm
What's up? Go ahead.
I am somewhat uncomfortable with it.
Okay.
Because I do think it should have been a zoning article.
Okay.
And even if it needs 2/3, that's probably the right thing.
Mm-hmm.
And I don't think it really should be a bylaw. And I also am concerned, I'm not saying we shouldn't have it, because I do think there's a lot of good things in this, so I really do. But I don't know what the effect is on some of the neighborhoods in the town.
Okay.
That concerns me.
Okay. Valid.
I don't know if anybody has any thoughts on that, but that's the thought I have.
I think what Ron said addresses that concern quite a bit, right? It is about the change in the light. So if you're in an area of town that has generally more brightness and you turn up and you go out for the inspection, the inspector measures with your light on, and then they measure with your light off, and it's the difference in illumination that is a determination of the violation or not. And so if you're in a more brightly lit part of town, you turning off your light individually probably doesn't change the brightness, ambient brightness in that area. So to me, that reassures me around that concern to the extent that maybe helps or not.
I thought that was a good point too.
And one thing I read in the measurement of it is the person has to turn off the light.
Yep.
Oh,
And they
hold
have
on.
to, they don't necessarily, have
Nope.
to.
Nope. I'm reading your mind. And was this Ron's wording? Whose wording? Somebody put in wording that addresses
Oh, they're not willing to help.
uncooperation. Where was the wording?
Non-compliant? Non-compliant?
I think it's a failure to cooperate.
Failure of the property owner. Come on. Failure of the property owner to cooperate with the inspection services department may be considered a violation. So if they say, turn your light on and off, yeah, because
You hide inside the house and we see you.
What is it? Get off my
because
property.
you have to turn your light on and off for them to measure it. If you say I refuse to turn it off,
No one can see you.
they'll say, well, no, it's not. So, good point. I cut you off. Was that addressing your?
Yeah, those are
Okay.
my issues, my questions.
Motion to vote.
Okay, we've been talking about a motion in a second. If there's no more discussion, so we are voting on the article. Are we recommending this article to town meeting? Karen, can you call for a vote?
Macy,
Yes.
Elaine,
Yes.
James Lee,
Yes.
Grace,
Abstain.
Larry,
Yes.
Andrew,
Yes.
Brian,
Yes.
Lee Michael,
Yes.
Ron,
Yes.
Nick,
Yes.
Cecile,
Yes.
Jay.
Abstain.
Motion carries.
Okay. So the only other things I want to talk about tonight are comments. I think I received comments from all but 2 or 3. I forget if I was counting this article or not. I sent you all the webpage where you can look at the comments. Again, it's not asking 15 different editors on every comment. Just sort of look at it. Do you see a horrible problem? Do you see something that can or should be fixed? We want to give this to the town administrator by Wednesday, I think, give or take. So please, toot sweet, look at them if you have an opinion. Let me know. I think me, Macy, and also Julia are the official editors. Contact the 3 of us if you have a question, complaint, issue. And for the 1 or 2 that are outstanding, please turn those around as soon as you can. Because again, we want to, it's going to the printer. I don't know if it's Wednesday or if he was just saying that to scare me, but pretty soon. Mr. Milano, if you're on, you can comment. Oh, hold on.
He just raised his hand.
Yes, you don't have to raise your hand. I'm lying. You do. I have power here. Mr. Milano.
I really don't have anything to add.
Please
You
speak.
covered it. Yes, this week would be great.
See, I said Wednesday and you're saying this week. I'm the mean parent, you're the nice parent. Okay. So comments. Move ahead quickly.
So we don't vote on comments.
We don't vote on comments. In
Yeah.
fact, in the past 3 years, we didn't even see comments till they are printed. So I'm trying to make it a little more democratic.
Great.
Also, my comment is out there, which my comment is pretty darn boring. It says, here are the articles we're looking at. But you can look at it.
I'll read it. Yeah.
Thank you, Larry. Thank you. That makes me feel special. Our next meeting, we have 4 weeks until the town meeting. I think our next meeting will be meeting with the school committee and the school superintendent to give us an overview of where we're starting with the budget. If I want to put things smack in the middle and give you a week off before and a week off after, then that would be Columbus Day. So if we still want the maximum amount of time to relax, we would meet sometime that is the week of Columbus Day, but not Monday. I proposed that today to the chair of the school committee and the superintendent. I didn't hear back, but I proposed that we could meet with them sometime that week. Is there a consensus around this table that even though it's violating the rule of we meet on Mondays, we'll get a week off with only me yelling at you about comments, and then we'll come back, meet with the school committee sometime in the middle of that week, and we'll have another week off, then we'll have town meeting. Does
So you're talking about the week of the 13th. Okay, Indigenous Persons Day is the 13th.
Okay, I didn't know what to call that day. But, okay, so the next meeting, I will try to schedule it for one day on that week at the convenience of the school committee chair and the superintendent.
And then town meeting is the 27th.
Correct.
Do you know if that's a week that the school committee has its regular meeting?
Oh, no.
Okay.
If they can't do that week, then we'll work around them. The only other thing is minutes. We got over a dozen minutes about 2 weeks ago. We could vote on those now. We could put that off. Certainly the meeting before town meeting is a good time to approve minutes.
Could I make a suggestion?
You can.
Can we vote on minutes at the beginning of these meetings?
So that it actually happens?
Yeah.
We had a guest here who had to drive to
Yeah, I
the
know, right, sure. Just an idea.
Yeah, I'm open to ideas. Macy, I'll leave it to you. Do you want to twist some arms and vote on some minutes?
Sure, let's do the ones that are recent.
These are just,
Yeah.
We've got, if our two remote members want to hang up, we can vote by hand. Just.
Bye, guys.
I didn't say that.
No, I
They are
didn't say
valued
it.
members.
I need Andrew.
hand up on Zoom just so.
I need Andrew
It's
because
the
some
law.
of these are from the last fiscal year.
Okay.
So yeah, right. So let's. So I'm gonna make a motion to vote on the minutes from September 8th of 2025 and September 9th of 2025. Those are
Okay, as a block.
Yeah.
Okay. Karen, so those two sets of minutes. Karen, can you call roll?
Sure. Hang on 1 second.
Do you need a second?
Gary, we can throw up hands. James Lee and I both threw up hands.
Not by the law. I don't want to get arrested.
And you don't, yeah, Ron's right. Did anyone second that?
I'll second it.
Ron seconded it. Okay. Macy,
Yes.
Elaine,
Yes.
James Lee,
Yes.
Grace,
Yes.
Larry,
yes.
Andrew,
Yes.
Brian,
Yes.
Lee Michael,
Yes.
Ron,
Yes.
Nick,
Yes.
Cecile,
Yes.
Jay.
Yes. Okay,
Motion
Macy, what
carries.
next?
Okay, so I'm gonna do a large block from the last fiscal year.
Okay.
So I'm expecting some people to abstain. So these are the minutes that I am asking for a vote. January 21st, 2025, January 22nd, 2025, January 23rd, 2025, February 3rd, 2025, February 5th, 2025, February 12th, 2025, February 18th, 2025, and, oh, sorry, thank you. And here, you're supposed to be going to sleep. February 10th, 2025, and May 19th, 2025.
Second.
Right. Karen, can you call roll?
Macy,
Yes.
Elaine,
Abstain.
James Lee,
Abstain.
Grace,
Abstain.
Larry,
Abstain.
Andrew,
Yes.
Brian,
Yes.
Lee Michael,
Yes.
oops, in the right spot. Ron,
Yes.
Nick,
Abstain.
Cecile,
Abstain.
Jay.
Yes. Yeah, as a reminder, you're allowed to vote on minutes
I
that
know.
precede your time. No, I just,
We could
Heard a
theoretically watch the
comment.
video, read it.
Yeah. You're allowed to vote, you're allowed to abstain, you're allowed to do lots of things. Okay, thank you, Macy.
You're welcome. You want another motion?
To abstain, to,
Motion to adjourn.
yes.
Second.
Thank you, everyone.
Night.
Chairman.
Like you guys met like every.